We ain't got no stinking video. That's what the Canton police told Karen Read's expert who had flown cross country to take a look at that video, the inverted Sallyport video. Canton police said, sorry.
Is there any way that the Sallyport video was actually missing? I'm Lainey Law.
And I'm attorney Andrew Myers.
And today we have the pleasure of having attorney Beto on. Mark, how are you doing today?
How are you guys?
Oh, we are doing, well, I would say we're doing great, but this is kind of a confusing situation to even get into.
It's not normal.
I'm shocked this even happened. Yeah.
This is not normal.
I can't say that I was totally shocked, but I was shocked when I first heard about the motion that Karen Read's defense attorneys have now filed, and we're going to get into it in a minute. But could it possibly be that Karen Read's attorneys would get the permission of the district attorney's office, the special prosecutor, Hank Brennan, to fly an expert in all the way from Arizona to go to the Canton Police Department? He gets there and the video is missing. Can that even happen?
Well, apparently it can, because it seems that it did here. It's hard to fathom that this process would be arranged and that a credible prosecutor would allow this to happen if they knew in advance that there was no such video to cull off whatever system they were going to do. Could be a situation where the DAs involved are not in the technical weeds. They just kind of delegate to other people to handle it, and they don't know. But, you know, at the end of the day, when you're the top of the food chain for the organization, you're responsible, so it does come back to you. So it's a really all around bad situation. It looks terrible for the Commonwealth. It appears to be part of a pattern of disappearing video and evidence that doesn't seem to be available. You know, we saw what happened during the trial with some of the video they even did produce, which was not even technically accurate. It's flipped around. I mean, this is the kind of stuff that in a case like this, that so many people already have strong doubts about the integrity of what's going on and the competence and confidence in the DA's office, the state police involved in the case, the Canton police, who ultimately had the video in this case. It's just another example of a case that is just a complete mess. It really is, from top to bottom, a complete mess.
Well, let's take a look at a little bit of the background. During the first trial of Karen Read, the Sallyport, the famous Sallyport video was put on. It was on for quite a while before the defense attorney said, hey, wait a minute, this is inverted. I don't like that word. It was backwards. And also, if you looked really close, there were times where there were jumps. Somebody would walk in and then they would jump out, or the very beginning when the vehicle was brought in, that was cut out. So with that background, Karen Read's attorneys reached out and said, we want the original video. And Hank Brennan himself apparently said, fine, you can go there and get that video. So they fly their expert in from Phoenix, Arizona. He goes to Canton. He goes to the police department where they have all of this video information. And what I don't understand is the video people were there. I guess they had a person, Colleen Crawford, who is the multimedia director, certified forensic video technician, but she's a non-attorney. In a site view or a view or something like this, shouldn't an attorney on the other side, somebody from the DA's office or someone from the Commonwealth, shouldn't someone have been there for that view?
I would think they would have someone there just to make sure the process goes off properly. The person they sent there, for lack of a better term, is just the tech guy, the IT woman who works at the office, which is fine. She would presumably have the technical knowledge. But in reading the motion, she didn't seem too surprised that nothing was going to happen during this process. Again, whether a DA wants to attend or not personally to make sure the process goes off smoothly, the buck stops with him. It's his case. He's in charge of it. It's his credibility that's on the line. And let's be honest, in this process, the person whose credibility, if you put aside the people involved with the Canton Police who screwed around with this video or accidentally deleted it. But in the current sense right now, it's not a good look for the prosecutor, the lead prosecutor handling the case a few months before trial, to have a defense expert come out for this process. And here's where we are. The other irony here is, and maybe the irony is not the right word, the awkwardness here is that the person sitting next to Brennan at the table, Adam Lally, he ought to know what the hell is going on here from the first trial. And this video, whether the original video existed in 2024 in December for the defense to get it, there are so many oddities surrounding the video, which ultimately I think may very well result in Lally having to testify at a hearing about what he knew and when he knew it. And anytime you're using those like Nixon catchphrases, it's never a good thing, right?
No, not at all. Well, here's why I asked that last question. I was involved in some litigation against a police department in Massachusetts, and we, called ahead through discovery. We were allowed to go to that city police department in Massachusetts. We got there, another attorney and myself, and before we were allowed to check in, we were held out in the anteroom. The city attorney came. I mean, otherwise, if we're there talking to police people who at whatever level they're on, that's talking to a witness. So the city attorney came down and ushered us through. We went to the Sallyport. We went to the cells. We went to the holding area where our client had been injured. So my point is, shouldn't an actual attorney from the DA's office or someone, either Mr. Lally or Mr. Brennan or someone else, shouldn't someone from the other side have been there to answer some questions that came up and that I want to get into in a minute?
I mean, you're asking me what happens at the Norfolk DA's office and their processes and whether it makes sense to people who've done this for a living or been involved in this process. It doesn't make any sense to me. In my days as a prosecutor, or even in undergoing something from the defense side that we're talking about, yeah, I would expect somebody, a lawyer, somebody high up involved in the case, to make sure and to document and witness everything that's happening to make sure that there are no problems. In this situation, based on what the motion says anyway, that wasn't the case. They sent the IT person and, nothing happened, and he just turned around and left, and $12,000 later, we're seeing a motion asking for the prosecution to reimburse the defense, which again, in a case full of, I've never seen anything like this before, but why am I surprised at this point? We now have a motion shortly before trial, a couple of months out, where the defense is asking for the court to order the prosecution to pay the defense. And when you saw a motion like that on the docket, most people, including myself, first reaction would be, why? That's just not generally how criminal litigation works. After you see what happened, you understand their frustration. And you also understand that this motion is the small potatoes motion. This is just laying the foundation for the nuclear bomb, which is coming, whenever, whether it's next week or shortly thereafter, where they're going to seek to dismiss the indictment for egregious misconduct, which I expect will go far beyond not preserving the original video, but it's going to go with the inverted video, the pattern of other evidence that they're alluding to that seems to have disappeared. Everything surrounding the video in this case is just bizarre. Missing ring video, missing library footage video, the comically late disclosure of the video that was disclosed in this case in the middle of trial, which, as I've said on other streams before, if that occurred in New York, that would have been an immediate motion for a mistrial, screaming and yelling about just an egregious discovery violation. The video that does get disclosed in the middle of trial turns out to be, as you noted, inverted, reversed, whatever you want to call it, which just conveniently conceals the rear right taillight, which is the whole case. You see the left taillight, which appears damaged in the footage, and which begs the next question: how the hell did that happen? You see people appearing and disappearing on the video, or if you like Harry Potter, apparating, what we've called it previously, seemingly just appearing and reappearing. Then you find out there's other video that they didn't disclose, which shows Brian Higgins creeping around the Canton Police Department after 1:30 in the morning on the phone. None of this was revealed prior to trial.
That was shocking, wasn't it? Let me ask you a specific question and your impression about. I always say the good stuff is hidden pretty far in. We're on page 18. This is part of the affidavit of the expert Matthew Erickson, picking up at the end of paragraph 7. And this is the expert, Mr. Erickson. I asked if they had a written protocol in January 2022 or now for saving video. They responded they did not. 8. The individuals refused to provide me with a copy of the original video files that they originally pulled from the DVR system, stating that the information had already been provided to the defense counsel. I found that shocking. I mean, he flies all the way from Phoenix, Arizona, and they say, no, we already gave it to him. Well, why didn't Brennan tell him that on the phone?
Well, you find it shocking. I find it childish and unprofessional. I mean, look, we're dealing with a very serious case. It's obviously a very high profile case. There's a lot on the line. These are real lawyers on both sides of this, a lot of money being spent. Everybody's preparing for trial. We were told that, there's a new sheriff in town for the DA's office. And the answer is, we're not telling you because we already told the defense attorney, so beat it. So give it to them twice if that's the case. But none of this even makes any sense because, again, where did the fakakta video in the middle of trial come from? The inverted video. If everything was taped over, did that just appear out of nowhere? I mean, if you're being told that this is a 30-day recycle and it's gone, then that means all the video would have been preserved back in, February of 2022. Why wouldn't everything, all of it, have been preserved at that time, knowing what this case is and knowing that this presumably will be video showing the SUV with the taillight and who's there, who's doing what? I mean, presumably this would help the prosecution. And instead, there's nothing to see here. Never mind the man behind the curtain. Disregard that. There's just nothing to see. And years later, it's too bad. You have what we have. And to this day, what I'm waiting for is an explanation from the prosecution for why piecemeal video was disclosed before trial, why that video was missing key parts that just happen to include the car coming into the Sallyport. How convenient. Why other video was only disclosed in the middle of trial, why that video turned out to be inverted, reversed, whatever the word is, blocking other things, why, although it also shows everything else at the bottom is not reversed, and the people are coming and going, suggesting it is not only inverted, but tampered with in some way. And then why is other video only appearing in October of 2024? And then when the defense learns about that video and they finally come out to see the original video, which based on this motion, in all fairness, you haven't seen the response by the prosecutor, but according to this motion, they were strongly led to believe they would have access to the original video. Then they get out there and are essentially told, oops, sorry, too bad. And we're not even going to show you what we used to acquire anything or what we did because the lawyers already have it. So have a nice.
And picking it up right there. I'm sorry, but to pick it up right there on this paragraph 8 of the affidavit, when I asked how they produced the footage to the court and or the defense, they seemed confused. I clarified by asking whether it was provided on a USB drive, a disk, or a share link. They could not tell me for sure, but eventually said it was probably a share link. Well, I explained that getting a copy of the video files directly from them would help us ensure that we're working with the same hash verified data that was disclosed to the defense. They continued to advise that I get these files from the defense and declined to provide me with any of the original video files. So who's on first here? Why didn't they tell them?
That's what I was wondering, because with this whole situation, that's one of my first thoughts. And, paragraph 7 and 8 kind of discuss this. And I'm curious on your guys' takes. As a computer science student, if I want to submit anything, I have to hand in very detailed files explaining exactly what it is. They have to follow a specific format and they have to be labeled a certain way. So I would think that for police submitting evidence that you would, one, have a standardized way of how you're sending it, but then two, if you're sending an altered video, a cropped video, you mentioned it getting dismissed in New York. I'm wondering, is like, wouldn't you have to submit the full video and then a separate second one saying that this is the edited video, explaining exactly why it was edited, what parts were edited out, what timestamps and all that stuff. So to me, this is just mind-boggling. How do you
Well, I think
lose such a big file? Like, how do you have no digital trace of where it was? How
it's
is the court not able to supply it and all that stuff?
it's crazy, but I think these are secondary concerns, and I think we're actually burying the lead on this. The lead here is there's no chain of custody. There's no protocol. There's no method in place. This is, you've heard of this legal term, a shit show. It's mind-boggling that a modern police force with a modern district attorney's office that is charged with the responsibility of prosecuting very serious cases literally has no method, no manner, no system in place to say, I can tell you how it was preserved because let me look at our records. Let me look at the chain of custody logs that, again, like the NYPD certainly has. When you get discovery in a New York case and you just get bombarded with papers, there are every single thing that is touched related to evidence in a case is logged in the system. There's a proper invoice that goes with it. They have something called a PETS invoice. I don't know what it stands for, PETS off the top of my head, but every time something's done, an entry is made right down to the day, time, to the second, who touched it, who did what, and they dump it on the defense and say, go have at it if you think there's a chain of custody problem. And of course, 99% of the time when it's being done properly by trained professionals, it doesn't. What you're seeing here in this situation is it's just a complete shit show where the left hand has no clue what the right hand is doing. They don't appear to care to know. And when pressed, fall back on, we'll go ask the lawyers in the defense because they got everything. This is embarrassing is one word to describe it. Shameful is another, obviously, but this should be disturbing. And the people that ought to be pissed are, some of these people who like to scream and yell and blame the many, many people who think Karen Read is not guilty, and that's fine. Everyone's entitled to their own opinion.
Right.
But the people who ought to be pissed are the people who have somehow convinced themselves that she must be guilty to say, because this is going to compromise that. This is the kind of stuff that even if you honest to God believe she's guilty, I don't, many don't, some do, whatever, that if they can't realize how harmful to the case is and how this is going to, feed into the defense. I mean, they're alleging some form of a police cover-up involving many people, and obviously the disgraced Proctor, soon to be ex-trooper Proctor, even today perhaps, and all these other people. You see reference to Buchanan in here. This is just going to look terrible and play right into the defense's hands. But at the same token, I mean, the defense, they, by not having the footage of the car coming in the Sallyport and showing the right rear taillight, I mean, they could be severely prejudiced. I mean, if that video existed and was preserved properly in the original format, and it didn't show the taillight in the condition that Proctor said it was when he first saw it in the Sallyport, there's no case. It's over. So prejudice to the defense is high. I would expect them, they're going to file a motion. I assume they're going to try to put Lally under oath to explain all this, as well as Buchanan, Tully, and others. I would expect if the case moves forward, they're going to seek a missing evidence instruction for the jury to draw an adverse inference that, had this evidence been preserved properly, that there's a decent chance it could have favored the defense. And whether that's the case or not, the mere fact that a jury might be instructed on that, and that there's an issue of destroyed evidence or discarded evidence, or even the negligent destruction or failure to maintain custody of evidence, when you factor that into everything else, leaf blowers, solo cups, other missing video, I mean, you could go on and on, right? The Scrivener's error that we were told about, the time that the car was, brought into the Sallyport and seized from Dighton. All of that is going to just favor the defense. And we're talking about reasonable doubt. We're not talking about who did what. We're talking
Right,
about
exactly.
whether any reasonable doubt, any reasonable possibility that Karen Read didn't do it based on the evidence presented. This is just another disaster for the prosecution. And there's really no spinning that. I mean, people online are going to spin it and talk about conspiracy theories and tinfoil hats and all of that kind of nonsense. But, you know, lawyers and professionals understand who do this for a living. This is a disaster for the
Yeah.
prosecution.
Let me ask you a question. Laney will tell you that I always think that the really important stuff is in the footnotes. Forget the body, the footnotes. Let me ask you about these two footnotes. A motion to dismiss for extraordinary governmental misconduct based on the destruction of this and other exculpatory evidence is forthcoming. This motion should not be deemed a waiver of any other claims or issues. So my question to you, specifically in the motion that we're talking about right now, all they asked for was for reimbursement of the money they spent for the expert, $12,000 and change. Is this a dismissible? Does this rise to the level of dismissing the case? That's apparently what our attorneys are going to ask for.
Well, it's unclear. I mean, because we need to know, first of all, again, in all fairness, the prosecution has not offered any defense or explanation for not only not maintaining the original, for the circumstances surrounding the inverted video, the circumstances surrounding why the inverted video was disclosed as late as it was. We've heard no explanation for why the Higgins video from October now that we're told about, which clearly was discoverable. And certainly, I would argue, if I were the defense, was exculpatory in the sense that it could have favored, doesn't have to, but there's a reasonable interpretation that it could have favored the defense in this case. Why that wasn't disclosed before trial. They're alluding to other evidence, which, you know, we'll have to wait and see what that is. But if there is a pattern of non-disclosure of discoverable and or exculpatory evidence, then in certain circumstances, a court has the power to dismiss the indictment as the ultimate sanction. Do I think that that would happen? No. But there are very severe sanctions that can be issued that are even short of dismissal. But really what it will come down to, I think the defense in filing that motion, the way I would do it, you want an evidentiary hearing. Okay, you want to get Lally up there. Let's hear it. Let's hear about all of these issues, not in January of 2025, but what the hell was going on in January 2022, February 2022, the disclosure of all these other piecemeal videos, why they're missing pieces, why you didn't have the original. I mean, that's the guy that should be answering the question. Or, you know, did you prep with Buchanan when this testimony came out? And I mean, look, remember at the trial, Buchanan was not going to offer on his direct that video was not even accurate, in the sense that it was a true, a fair and accurate depiction. He made no reference to it being inverted, and actually identified himself and Proctor, and then got a quick case of amnesia on cross-examination when it was clear that had in fact been inverted. That's troubling.
Well, don't you think that they're not going to put Lally on the stand? They're going to have, that's why they have this Colleen Crawford. She is actually
no. I'm talking, and the defense at a pretrial hearing will demand and that Lally testify. And honestly, in good faith, if we're going to determine whether they specifically suppressed favorable evidence before the trial, during the trial, and even after the trial, and before the retrial that's happening, then guess what? Lally's going to be testifying. If the defense,
I would expect that Lally will bring a motion to quash any subpoena, and then I think that's why they have this Colleen Crawford. She's I don't know what this is, but it's maybe Laney can help me. She's a certified forensic video tech. What is that? What is a certified video technician?
She took some classes and to specialize in something.
Points. Number one, I don't know her. I'm not going to disparage her. She's an IT person. She's a technical. She knows a lot more about video than me, probably you. I don't know.
Yeah, absolutely.
Let's just take her at face value. And I agree, she would testify. But if there is going to be a motion to dismiss based on the suppression of exculpatory evidence before the first trial and during the first trial, the person who's in the crosshairs there is Adam Lally. Okay, the buck stops with him. And one could even argue Michael Morrissey, depending on what he knew, but put him aside. He's a figurehead, perhaps. Lally has his hands in the pie. I mean, he is ultimately the responsible individual for supervising the prosecution and having the possession and custody and control and the ethical obligation to know if there's favorable evidence or discoverable evidence and to disclose it. So there is no way, if this motion is filed and there needs to be a hearing to decide this issue, there is no way that he doesn't testify. Now, he may submit an affirmation in the defense prosecution response, to this motion, but that's probably not going to answer the question. I mean, a self-serving affirmation from him saying, I didn't know about this, or I only learned about this after, that's not going to answer all the questions. This is a mess. There's no real good way to spin this. It doesn't mean the indictment is going to get dismissed. It doesn't even mean that this was on purpose. But, let's also be clear about Brady. Brady is an affirmative obligation that does not require bad faith. Okay, when we use the word suppress evidence, really what we mean is non-disclosure, right? That they were obligated to disclose. It doesn't even have to be intentional. Of course, it's worse when it's intentional.
Right.
And certainly the argument for severe sanctions, including up to dismissal, are much stronger if it turns out to be intentional. But the real question is, why wasn't all of the video in proper form disclosed before trial? Who can answer that question other than Adam Lally?
No, I agree with you 100%. And the case law that is cited in the motion we're talking about, in the innards of the motion, I think it's one of the last 2 or 3 pages, says, as you just said, it doesn't have to be intentional. It could just be negligent, which is probably what it was here. And you mentioned Morrissey. You mentioned DA Morrissey, who's up for re-election in 2 years from now. He has put his fingers in the pie by releasing that video that he released, I think it was in early 2024, in which he said, we want you to stop it, back off right now. And then he cited the evidence that was going to come in. We have cell phone and he's already put his hand deep in the pie. He can't say that he was just up in his administrative office drinking lattes.
Yeah, no, it's a problem. And that hostage video that he made on behalf of witnesses in the case, that was from the summer of 23, I believe, just a few months after there had been some publicity about prosecution witnesses allegedly being involved or covering something up and all of that. And he took the virtually unprecedented step and made a mockery of Rule 3.6, related to trial publicity, and gave his version of what was a summation defending the integrity of these witnesses, and even made statements which turned out to be factually false about Proctor not knowing these people. That was just pathetic thing to do. Yeah. So his fingers are potentially in the pie, but really this is a Lally problem there. And when you say it's probably negligent, maybe, but there are some signs here that really suggest that it may very well be intentional. Now, that doesn't mean that Lally knew that, but again, when we talk about, intentional misconduct, it doesn't just have to be the prosecutor. It can be the police department or anyone acting under their authority, which would include the Canton Police, the state police, anyone in the DA's office. But again, some of the video here was turned over in inverted form, and it literally concealed 2 key facts. It concealed the condition of the right rear taillight, which is the whole case, really. Yeah. And it concealed that what appeared to be Michael Proctor in the immediate proximity, or somebody to the right rear taillight doing who knows what. We noted that the rest of the video suggests it might have been tampered with. The people that were coming in and coming out of the video, that's not necessarily an error in transmitting. That feels altered, tampered, edited.
It feels like somebody edited it. Yeah,
that's intentional. And the other thing, again, help me understand this. When you look at the inverted video, even though they're attempting to show you the right rear taillight, which you now know is in fact the left rear taillight, which all parties agree in the real world is in pristine form. Nothing happened to it in the real world, but on the video, it looks as if it may be cracked, because there's like white where the red should be, where in what appears to be the right side is in fact the left, and a
Right.
taillight that is in fact in pristine form appears arguably to possibly be cracked or shattered. That's disturbing. So these are all, and then you can't ignore Buchanan's testimony, which is, oh yeah, look, there I am, there's Proctor, and everything looks hunky-dory. And
In the
then,
back corner. Yeah, they were in the back corner there.
and then all of a sudden, it is flipped, and now, I don't know who those people are. This is troubling. And they've never answered why this was disclosed in the middle of trial. And I've never understood why that didn't lead to an absolute chaotic scene where again, a discovery violation of such critical evidence mid-trial is just the worst form of sandbagging the other party, right? I mean, that's hideous. And
That's the word I would have used. I love that word because in my world, and I try mostly civil. I've dabbled in criminal, but I do mostly civil. If I come into trial and I try to show some piece of documentary evidence or video that I haven't disclosed in discovery, the judge is going to do one of these and kick my you-know-what and say, no, that's not going in. That's not going in.
One of the other problems, and again, judges do it their own way. In this particular case, most of the sausage is made at sidebar. In fact, almost all of it is.
Yes.
And that's unfortunate because we don't know. There was a sidebar when this issue came out. Now, was there a mistrial application made at the bench? In other words, on the record, preserved,
Right.
but nevertheless not released? I don't know. But there's no reason to protect that. Again, I understand judge wants to have control over a courtroom, but trials are presumed to be public. There are reasons why certain things ought to be done in private, or as I'm learning Massachusetts terminology, where they like to impound everything like that. It's like so easy to do. But a mistrial application, if it were made on the basis that the prosecution did not disclose discoverable evidence and then may very well have tampered with the evidence, then the witness may very well have perjured himself, describing it as legitimate. There's no reason for that not to be heard loud with a bright light shining on it, and then the judge makes a ruling. But I don't know whether that application was made, but if it was made in private, which I think is very unfortunate.
Well, if they had disclosed the video in advance, if attorneys Jackson, Yannetti, and Little had gotten that video in advance, they would have had time to screen it. And their paralegals would have had time to screen it, and they would have known it. And either they would have known right then that it was backwards, or when we get to the trial and day whatever it was during Karen Read 1.0, when they saw it and they would have known right away. So it is a case of sandbagging. I think it is a definite case of sandbagging. And again, I don't think, in my experience, if I came in at the last minute and said, oh, here, judge, I want to show the jury this, unless I've shown it in discovery, it's not going in. So it was shocking. That's a shocking miscarriage.
It is,
in my view,
totally outrageous, and it is sandbagging. There is no other word for it because, again, forget the Twitter trolls and the people who, none of this matters, and this is your typical scummy defense motion.
Yeah. No.
Ask any lawyer who defends criminal cases and has a presumption of innocence, due process on behalf of their client, and a vigorous defense, and say, how would you just got critical evidence disclosed in the middle of trial. It's falsified. It's certainly not accurate evidence. The testimony about it is false. It's clearly material to the issues at hand. And not only that, it's missing pieces. It's not the full video. You're going to get more video after trial. How do you take that? Ask any defense attorney. And I would suggest to you, ask one defense attorney in particular. Ask Hank Brennan. If you were the defense attorney in this case, okay? Any defense attorney confronted with this,
he's going to scream bloody murder.
I'm having a stroke demanding a mistrial about how outrageous it is. And again, you can't forget, it's not just the inverted video. The piece of video they got before trial is missing the critical portion of the car coming in the Sallyport.
Right.
Even when they get the inverted video, they're still missing video. Now you get this Higgins video, but you don't get the original. So it's blurry. Now you don't know, Higgins' testimony at trial a second time around, you go back and look at the transcript of what he said the first time. Now he's going to have to explain why he's walking around, the Canton Police Department at 1:30 in the morning, calling someone. Who's he calling?
That's the other bombshell. I don't like that word bombshell, but to get away from the video for a second, that's the other thing that really struck me about this motion, that they actually have video of Higgins walking to the Canton Police Department at 1:34 a.m. On January 29th of 2022. That would have been approximately about more or less an hour after Karen Read is said to have dropped John O'Keefe off. So wait a minute. I thought that in the first trial, wasn't he butt dialing because he was home doing things? I mean, so where was he? Was he at home? Was he at the police station? How does he explain that?
I think what he said, and again, others who are more in the weeds on a day-to-day basis, people find this hard to believe, but we actually all have jobs and have to earn
crazy.
And literally don't study transcripts. We're what they call part-time grifters. But my recollection of Higgins's testimony, and again, even at the time, without knowing about this video, on its face, it was wow. He leaves the house on Fairview Road, goes to the Canton Police Department. He's presumably intoxicated, right? He's been, drinking his ginger and Jamesons or whatever, because he went there to move cars. Then he went home to, I think at the time, or his flop house, which was in West Roxbury or something. And he fell asleep on the couch. He has no explanation for the butt dials. But, 1:34 in the morning is approximately an hour after, if you go by the prosecution's theory, John O'Keefe is lying dead on the lawn or close to it. Maybe not dead, but certainly on his way to a very untimely demise. And, he's moving cars and he's making phone calls. Who's he calling? Is he calling Brian Albert? I don't know. Is he calling Chief Berkowitz? I don't know. Which phone is he using? He had two phones. We know he went to get one of his buddies in law enforcement to help him, do his own version of an extraction. We know he got rid of his phone right around the time of a preservation order, around the same time Brian Albert did. He was butt dialing an hour later, back and forth with Brian Albert. There's other little interesting things. I don't know if you remember this, but that as part of Jennifer McCabe's cellular records and data, that there was like a new contact created for Brian Albert, and a photograph of it, which was then deleted right away. Does that relate to some of this? I don't know. But the point is
interesting.
The defense had the absolute right to grill Higgins at trial and not just rely on what he says he was doing, but say, what are you doing creeping around the Canton Police Department at 1:34 in the morning? Why are you inside if you're there to move cars? Is there video of him, getting ready to move cars? I don't know. Who knows?
Why are you drinking, moving cars, going to work in 2 a.m? Like, who wants to go to work?
Why are you doing any of that? Who are you calling? Now I know, but some people say that he was confronted with some call records. That may be true. I don't know what's on those call logs or how authentic they are. I don't even know which phone it is. The guy had two phones. He had a work phone and a private phone. We don't know. So there's just a lot of troubling coincidences here. It's, we don't know what the missing ring video would show. It just doesn't exist. You don't know what the missing library video would show. It just doesn't exist. You don't know why Michael Proctor said he got the car in Dighton at 4:12 p.m. or at 5:20 p.m. when he flipped the times. And then he said it was a scrivener's error, even though none of the mistakes he made are numbers that are even next to each other. We don't know. We don't know how we ended up with inverted video. Who knows? Why did Jennifer McCabe have all these deletions on her phone? We don't know. Why does there appear to be all these other call records that don't make sense? We don't know.
Well, yeah, we've heard all of this before. We don't know why this happened. We don't know why we don't have. I don't know why Higgins got rid of his phone. But isn't this kind of a showstopper? Isn't this the final nail in the coffin of the whole prosecution, which has had so many? I hate to use the word shady things, but so many shady things happen. Isn't this kind of a showstopper where the court should probably wake up and say, "Wait a minute, guys, I'm not going along with this anymore. This is it." Shouldn't this be a final kind of
I
nail
was
in the coffin?
very concerned during the first trial when the inverted video happened that there was not action by the judge to say, time out, what the hell is going on in my courtroom? And I'm looking at you, Mr. Lally. What the hell is going on here? I want to hear now how this happened and know everything. And she didn't. And I found that troubling. And now that issue still exists. But now, you've come to learn that there is other video that they just somehow belatedly disclosed. There is this issue that they have no ability, apparently, to locate the original native video. They have no policy to try to preserve it. They have no chain of custody. They didn't even try to do it. They hauled the defense experts out here, presumably knowing that there was nothing to find here. So now you add all these issues on top of it, and people are going to be watching. How does the judge react to this? Because again, we can only go on our own experience. I don't know how things are necessarily handled, but in my experience, every single judge, to a man and woman confronted with what happened with the inverted video in the middle of trial, would have said, time out, tell the jury, step aside, get him out of here because it's going to get loud, and found out what the hell is happening in my courtroom. And in this case, that didn't happen. And there didn't appear to be much. I mean, I know, again, there was a sidebar application or something, but beyond that, it was just, let's get back to work. And that's mind-boggling to me that anybody would think that level of sandbagging and non-disclosure combined with all the other oddities that have occurred in this case is okay when it's not.
Well, I was going to ask you the question of what you thought the judge would do, but you already kind of answered that. So I'm going to back up a little bit and point out that my crystal ball is still broken. But based on what you've seen of Special Prosecutor Hank Brennan, based on all the motions that we've seen, with respect to the ARCA experts and with respect to Dr. Russell and Richard Green, and also seeing his courtroom manner, based on all of that and your observations, what do you think will be Mr. Brennan's response to this motion? I have an answer, but I'm curious as to what you think he might say or do.
Well, again, they're in a tough spot. Again, he's responsible legally for Brady and discovery issues up and down the food chain, whether he individually knows or doesn't know. On the other hand, he doesn't work there. I mean, he's a ringer on this case. Okay. He has a professional reputation and private practice that he's going to be concerned about, and rightfully so. Okay. If something happened here, the question becomes, is he going to vigorously defend the office and go down with the ship? Or is there going to be a self-preservation here to say, whatever happened, it ain't me, babe. I had nothing to do with this. So the real thing is, I don't assume that he deliberately did anything wrong here and knew that he was bringing out these defense experts on a wild goose chase for no purpose. I don't assume that I don't think actually he would do that personally. Again, I don't know him individually, but I just, based on his experience and level of practice, that would be a real sleazy thing to do. I don't think he did that, but he's still responsible. So the question is, let's assume that he individually had nothing to do with this. How do you defend it? Or do you throw Lally under the bus? Lally is in the crosshairs here, okay? He is the key master. He knows what's behind every door as it relates to these issues. So how are they going to respond to this? If you're Brennan, is he worried about his own reputation, the prosecution as a whole, defending the case? I mean, you start to wonder if the interests start to diverge a little bit. In other words, is it in his interest to get the hell away from this issue personally for his own reputation? Maybe, especially if he had nothing to do with it, as opposed to, I'm going to defend this conduct. And in the process,
I think I know what he's going to say. I don't have a crystal ball and I don't know the man well. I've met him a few times, but I don't know him well. I think this is what he's going to say. He's going to say, okay, I just read the motion, and notwithstanding the Brady law that we mentioned before, that it doesn't have to be intentional. It can just be neglect. He's going to say, Oh, I wasn't. I thought you were going to call when this happened, and we read paragraph 18 in the affidavit before about the people in the police department in Canton saying, "What? Huh? No, we don't know. Huh? No, we don't know." He's going to say, A, like you just said, I had nothing to do with it. But B, when I said, "Sure, come on over here to Massachusetts," why didn't you call me? You should have called. You should have called me. I was in the office. You could have come down to Park Street, or you could have come down to the DA's office. I have that tape. You can come get it. That's going to be us out, and the judge is likely going to say, "Gentlemen and ladies, this is a new day. Move on."
Well, again,
That's my guess.
I don't
I
know.
hope it doesn't go down that way, but that's my guess.
I don't know tactically and strategically what they're doing, the defense. I'm not privy to that, but what I would suggest based on having experience and common sense and reading what this motion is a placeholder. Okay. They didn't do this to file a motion saying, "Pretty please," with a cherry on top, "Can you order them to give us $12,000? I don't know that the judge is even positioned to have the authority to do that. Nobody cares. The most important thing in this entire motion is in the footnote that says the nuclear motion is coming, and it goes beyond this. And that's what this is. This is like a jab setting up the haymaker that's coming, and they're going to have to answer it however they answer it. And again, they have a right to answer this. They may have a very good explanation. Certainly what's being suggested here is deeply disturbing, and a lot of it involves facts that are irrefutable. They did not disclose the inverted video before trial as they should have. They did not disclose it in the proper format as they should have. They did not maintain the original video in its native form as they should have. They did not disclose other video, this Higgins video, prior to trial as they should have. I mean, there's just a laundry list of too many things that this prosecutor's office does not do that they should have. And there's no escape from that. Whatever the ruling on the motion is, their level of practice in honoring their discovery their discovery obligations is, shall we say, to be kind, less than standard.
Yeah. Your client kind of took that footnote that we just looked at, and I don't want to say he tweeted it out. What do you call when you posted on your Facebook page?
Oh, this looks like X or Twitter, but it's also, I don't know, Facebook post.
Yeah, so that footnote was.
I mean, that looks like the mechanism of Twitter X, whatever.
Twitter, yeah, Twitter X. He's Xing.
Typo. We got the wrong number, but everything else, I think it was just really a cut and paste from the footnote that we just looked at. So we're all waiting for the other shoe to drop with the Supreme Judicial Court. I keep checking every Friday because you and I had talked before, and we kind of agreed that it'll probably happen at 4:49 on a Friday. So
preferably a holiday week, or yeah. But
well, we're already past Christmas and Hanukkah and New Year's, so I don't know what holiday is coming up. I guess Easter. Is Easter before or after the trial? The trial is April 1st. Yeah.
Maybe
so anyhow,
warm-hearted, it'll be on Valentine's Day or thereabouts.
Yeah, I guess so. But so that was one of the big surprises to me in the motion, that Brian Higgins had shown up at the police department that night, and I would like to see that video. I'd love to see it. It's just something that's out there.
Well, you're going to see it because he's going to be confronted with it, and he's going to have to explain what he's doing, who he's calling, and why he was doing this. And, I mean, he's going to have to answer to it. And we know he's represented. We know he's had some certainly issues at the first trial. He didn't have smooth sailing. And this is just going to be another topic for him that he's going to have to handle. And with everything else, to me, it's just another problem that they're never going to get past when you look at it with reasonable doubt. And all the people who scream and yell about this case online and are so invested in this, all they talk about is like, she did it, she didn't do it. And that's all wonderful, but that's not how lawyers look at this, obviously. And that's not how a jury will be instructed to look at it. They're looking for whether there's reasonable doubt or not. And all of these issues are picking at more and more reasonable doubt. To me, I just can't fathom that the prosecution is going to get past all of this. I don't see any way that they're going to be able to do that unless we're all missing something.
No, I agree with you. Lainey, any closing thoughts? Mr. Bedro, thank you so much for your time. Lainey?
Yeah, so I just want to, as my closing thought, just mention how you made a good point where there's no system of how they're doing any of this. And whether somebody thinks she's guilty or not guilty, I think you did a good point at highlighting it doesn't matter whether she's guilty or not guilty, because this, no matter who you are, this could be something that impacts and affects you. If you just happen to be so unlucky to find yourself in trouble with the police department or any situation, or even just a regular case that doesn't involve the police department, how are you going to trust them to securely handle your evidence if there's no standards for this? There should be something very set and clear. If I am not even like a professional working at the police office, if I can sit there and be like, why were there not two separate files for this? Why weren't they in their own unique folder? Why isn't there a digital trail?
It's
we can
even
say that from the outside. Yeah.
Even worse than that, because the problem they're going to have is you have master lawyers in the form of Alan Jackson and David Unetti. They know what they're doing. They know how to sum up. And of course, anyone who is gifted at the art of summation is gifted at linking evidence, or what lawyers call marshaling the evidence, and strengthening a point with another one and tying them together and kind of making that snowball grow. And when you to just work off what you just said, when you talk about there's no chain of custody for video. I mean, they literally, not only is there no chain of custody, there's no system in place to even attempt to do anything. And let's be clear, they had 30 days. They had that time. They knew that this car, from their theory, was the instrument of death. Okay. They knew that that video was going to be key. And so now you take that point, take that missing evidence charge that they probably will get, but now marshal it with, they didn't secure a crime scene. They literally gave the case away within an hour. They went and got, the solo cups.
They got stop and shop bags
with blood evidence. We never got ring video from neighbors. We never did this. We never took a photo of the taillight. When you start piling all this on top of each other, what a jury is, again, knowing the burden of proof on the prosecution, what the jury is going to do most likely is this: get out of here. And what's fascinating to me is that the people who are obsessed with believing that Karen Read is the devil incarnate, she's guilty, she's responsible for cancer and everything else that's terrible in this world, has got to be on her. They have misplaced anger. They can think she committed a crime and is not taking responsibility all they want, whether they respect her right to due process or not. But the people that they should be angry at are the Norfolk DA's office, the Canton, Massachusetts police, and the Massachusetts State Police, because the kind of stuff that we're talking about right now, they screwed it up. And if she was factually and should have been legally guilty, these kind of mistakes are going to help make sure that that doesn't happen. So they should really rechannel their anger towards the just atrocious investigation, if that's even the right word, for what happened here on John O'Keefe's death.
I want to close with a really absurd thought. I was listening to everything you said about chain of custody, which is so important. You were talking about the PETS logs in New York. I've seen the same thing in drug cases where they've got to document everything from the time they found it to the time it went to the log. Somebody logged it in, somebody logged it into the test.
Anybody touches it, there's an entry.
There's an entry, and I've seen it. Here's my absurd thought. I've been involved in slip and fall litigation against big box stores, and you've been at all of them. And they come back to us during discovery with a floor sweeping log. I swept aisle 16 at 4:43. I swept aisle 12 at 12:23. And not only that, the maintenance person who swept aisle 3 signs it, then the supervisor signs it, and then the store manager signs it. So if XYZ Mart that you've all been to is able to log a chain of evidence on sweeping the floors, why can't the Canton Police Department do the same thing? Mm-hmm. It's absurd. So that's my closing absurd thought.
But they can. And of course, one of the defense argument is going to be they deleted, they tampered, they obstructed. I mean, that plays right into the defense theory in this case. The argument is going to be there's no video because they don't want you to see the video. The video that you got is inverted because they want you to think that the right tail light is over there when it's really not. And what is going to be the argument for the prosecution? Again, they have the burden of proof. They're on the defensive. They're trying to justify all of these things, and they're going to be offering speculative reasons as to how this happened and why it doesn't matter. And we say this all the time. When you're the party with the burden of proof and you're on the defensive and you're trying to explain and speculate, well, maybe it's not a big deal. We can explain this way. And here's another problem. We can explain it that way. And you're the one that's trying to plug the dam with your fingers and the water's.
Yeah, it doesn't wash.
You lose. The burden of proof is everything. You lose. And that's the people who watch this, the people who hate us, the people who like us, they need to recognize that. We don't write the rules. The United States Constitution writes the rules.
235 years ago or whatever. Yeah.
And the rules are burden of proof is on them beyond a reasonable doubt. And in America, that's how it works. And it's going to be a problem for them.
Okay. Thank you so much for your insight. It's always a pleasure speaking with you. You have a lot of insight. And so on that note, I will say thank you for being with us, and have a great time down there in New York. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.